Now, how do we start protecting our intellectual property? Well, the first step is to create it, and you all have created it. You all have brand names, logos, slogans probably, creative marketing materials, source code, websites. All of these things are content. You're creating it. That's the first step. That's the good news. You already have it. You use it. You're already using it. That's, again, good news. By using it, you're establishing some rights. The next step is really to identify and isolate it. And that's where I think that many businesses can benefit from taking a step back and saying, wow, I knew we had intellectual property, but maybe I didn't know that we had all this intellectual property. I didn't realize that our whole series of articles on our blog, or our newsletter that we publish to our clients once a month via email, is intellectual property, and I own the rights to that content, and I could license it to somebody else. I certainly should be able to make sure that nobody else is using it, and there's a value to that. If somebody wants to invest in my company, or somebody wants to buy my company, I have all of these intellectual property assets that I can tell them about, that I made them. Obviously I knew they existed, but I never really identified them. I really never thought of them as part of this base of assets that are part of my company. So once you've created it and used it and identified it, you can take steps to protect it. And some of the steps are very easy and very free. I guess very free is redundant. They're free. For example, on trademarks, when you're coming up with a new name, the best thing you can do is to make sure nobody else is using that name in your space, in your industry, in any related industry before you. And that means checking for similar spellings and spacings and sounds. Ideally, it means retaining somebody to do a professional search, but at a minimum, it means searching the publicly available records of the U.S. Patent and Trademark Office if you're doing business in the U.S., other countries if you're doing business there, and checking the major search engines and domain name registrations. Because the worst case scenario with a trademark is that you come up with a new product, you put a lot of heart and soul and time and money into it, you create it, it starts to take off, you're gaining traction, you're getting users and sales, and then in a year you find out that somebody else has some little known product with the identical name that you never heard of, and they've been using it since before you, and they're telling you you've got to stop using that name right away. And now all of your marketing is out the drain, you've got to explain this to customers, you've got to sort of rebrand, and all of the costs and time that could be associated going into that. Or face litigation. So it's really, a lose-lose situation, because your only two options are to litigate it, maybe you do have a case, or to change. And obviously there are costs associated with both. In addition to searching a name, I believe there's a great value in choosing a strong name. There's a spectrum of names. If you think about many of the, if not most, of the very successful new brands in the last 5 years, they have very creative names. Google, eBay, Amazon.com, Craigslist. All of these things, now I say them, you know exactly what I'm talking about, but if you had never heard of eBay and I said you got to check out eBay, what does eBay do? I don't understand. What does that mean? So they took a name that doesn't really have a lot of meaning. It may be a little bit suggestive of what they do. Amazon is a little suggestive because it's suggesting, that it's this giant thing that has all different types of resources, all different types of products. But it doesn't directly tell the customers what they're doing. It's not like a name like streaming music online. Sure, if I saw that name, I would know exactly what it was, but it wouldn't be catchy, it wouldn't be easy to find them. If I did a search for streaming music online, there's probably 2,000 websites that come up that use that as a keyword. If I do a search for Pandora, I know what I'm looking for, and I know what I'm going to find. So stronger names are either arbitrary, meaning they really have no relation to the product, like Apple for computers or Amazon for online retail, or they're suggestive, meaning they give you a little bit of an inclination, but they don't go as far as being descriptive or generic. So Google is a little bit suggestive because it suggests a huge number. And many other names that are really good names are suggestive. It's not a software name, but you notice in the elevator at the hotel here, there's a sign for the gym, and it's called the Stay Fit Gym. Well, Stay Fit is a great creative name because you're traveling and you're staying fit, and it's the gym at the place where you're staying. So it's a double entendre, and it's catchy. And so for a trademark geek like me, when I saw that, I smiled. So those are the best kind of names, suggestive names, because they do tell the user a little bit about what they're doing, but they're strong enough to really protect and to be unique. So once you have a trademark, you want to use proper notice and proper use of it. That means using a TM if it's a product, which software is generally considered a product even when it's online, or SM when it's a service. And once it's registered, if you register it with the USPTO, you want to use the R with a circle to tell people that it's registered. That helps scare off potential copiers. Another good reason to file and register it is that you then show up in the database at the US Patent and Trademark Office, which, as I advised, and hopefully many others are advising people when they come up with a name, they search there first. So if you're in that database, hopefully just showing up in other people's searches is eliminating conflicts before they even have a spark of life. Registration also has a lot of other benefits. It allows you to get a lot more money more easily in court and dealing with infringers. The government filing fees are approximately $300. And in the end, if you get a registered trademark, it's a tangible asset. You have a registration number, you have a nice certificate with a seal from the federal government, and you can actually assign a value to this in accounting or in business deals. And if your company is being sold, this is an asset that is listed among the assets of your company, just like all of your servers and all of your furniture might be listed as assets. Your intellectual property should be listed as assets as well. And registered trademarks are very, very good and valuable assets, as we've seen, because without a way to find your product and to come back to your product and to tell people about your product, the product's value is certainly diminished.